Now we're talking about another major part of a corporation, which is the shareholders. Read the chapter objectives on your own. And shareholders' role is, to be kind of blunt about it, is to pay for stock. They also get to elect directors and they can vote on certain issues, but that's their number one role, is to pay for stock. Now they do have rights. They get to vote. They get to liquidate or get their shares if the company goes under. They can get a portion of the corporate profits if there are any left over when the corporation sells. They can sell their shares, and they can also have preemptive rights. Now, we talked about preemptive rights in a prior chapter, but it bears repeating. So, if this is actually talking about the liquidation rights up above, but preemptive rights are basically, to remind you, preemptive rights are when a company is issuing new stock if a shareholder has the rights to buy the same ownership percentage in that new issuance of stock. Liquidation rights, which this is talking about down here, is if a company dissolves and after they pay their creditors they have $10,000 left, then if a shareholder owns 5%, then they will get 5% of that $10,000, which is $500. Shareholders also have the right to view the financial records of a corporation, and this is huge because this lets the shareholder know if they've been being paid properly or not. So a lot of times there's lawsuits if the financials are being hidden because people want to know how much they are owed. And also shareholders can look at a list of other shareholders so they can see if they want to get together and vote as a group. Now, sometimes shareholders rely too much on litigation to fix problems with directors instead of really carefully voting the directors in before they're elected. And this is because it's hard enough to vet our politicians, much less if we are looking at directors for a corporation. So a lot of times things are sued on after the fact. Now, directors can be removed before their term is up. And again, like we talked about last chapter, there is cumulative voting that can be used for directors. And the shares are multiplied by the number of open positions. So there's 2 open positions and 3 directors running. You focus on the 2 open positions and the number of shares. So 2 times 50 equals 100 votes. Don't focus on how many directors are running. And shareholders could also be asked to vote on amending the bylaws, dissolving the company, voting on whether there's a conflict of interest the director has and whether that's fair to the corporation or not. Now, there are 2 types of lawsuits that basically shareholders can have against the company. And one is a direct action, so a shareholder directly sues the company for something that was done to him or her. And typically you have to have a certain number of shares in order to sue this way, and that number is usually 10% or more, and you'd be alleging something like you were denied your right to vote, your right to look at the financial records, or maybe you didn't even get a dividend when the rest of the shareholders did, that sort of thing. Now, derivative is somewhat like a class action lawsuit because typically a shareholder with less than 10% has to vote this way. And so, kind of small potatoes as far as the corporation's concerned, but it's important to that shareholder. And oftentimes they'll band together with other shareholders. Now, there's going to be a lead shareholder, and if everyone gets reimbursed, great, then that shareholder gets a little bit of that piece. So that's kind of why I compare it to class action. Typically, no one gets rich this way. So it's a shareholder basically bringing lawsuits in the corporation's name. And a director can bring lawsuits in the corporation's name, but sometimes the director is the reason that there's a need for the lawsuit. So then the shareholder can sue on behalf of the corporation for wrong that's done to the corporation. And in order to sue, they have to be a shareholder at the time the incident occurred. They have to represent the interests of the corporation, and they have to ask the corporation to fix it, and the corporation cannot have done so. And typically, the nice thing about being a shareholder is they have limited liability and can only lose up to the amount of their investment. Now, sometimes we need to pierce the corporate veil. The veil acts as that limited liability between the public being able to sue the shareholders. And sometimes the shareholders are the ones mistreating the corporation, and so the public needs to be able to break through the corporate veil and sue the shareholders directly. If the shareholders are treating the corporate's bank accounts as their own or commingling of assets, this is a reason to pierce the corporate veil. If the shareholders are not holding meetings or not taking minutes, this is a lack of formalities and a reason to pierce the corporate veil. And if the shareholders do not adequately capitalize or start the corporation with enough money, this is another reason to pierce the corporate veil as well. Now, shareholders can have annual and special meetings, and the annual meetings must take place yearly like they sound. That's when they elect directors, and they have to have a quorum, and typically a quorum is anywhere from 1/3 to 51% of the voting shareholders in this instance. Now, they might have a special meeting in case a director has been acting with misconduct. Who gets noticed as a shareholder is who owns shares on the date, the record date. And we talked about that before. The record date's usually 30 days before the shareholders meeting, and it's a line in the sand. And who owns on that date is who gets notice. Who owns on that date is who gets shares. Now, any notice of meetings has to be include the place, time, and date of the meeting and the purpose of the meeting. And if the shareholder does not get proper notice, then they have to waive it or come to the meeting without objecting. Otherwise, it's not valid. Now, a shareholder, especially if they don't have a lot of shares, might not want to come to the meeting because it might be very costly. So they can do what's known as a proxy, or also kind of like an absentee ballot. It gives somebody else the right to vote on their behalf. And so here's an example one that you can read. And proxy statements are regulated by the Securities and Exchange Commission. And shareholders have the right to revoke the proxy. Now, there's also going to be a corporate's minutes book, and this might be online, that keeps all the records of the minutes of the meetings, notices, consents, articles, and bylaws. All the documents of the corporation need to be kept and be available for inspection by the shareholders when they so desire. Now, it's very unlikely that there will be an action without a meeting by the shareholders. They could if they have written consent, but this usually takes a majority or unanimous vote of shareholders, and so this is harder to do the more shareholders you have.